Sir, stop right there. ID, now.
Of course, I work here. I'm a law clerk.
Law clerk at the Supreme Court.
That's my official credential. Verification number is on the back. Call the security desk.
Anyone can print something like that.
A man walks up the steps of the United States Supreme Court building where he works, carrying the credentials that prove it. A police officer stops him, takes his badge, laughs at it, pockets it, and puts him in handcuffs. Marcus Reid is 29 years old, graduate of Howard University School of Law, summa cum laude. One of 38 law clerks selected that year to serve at the highest court in the United States. Clerk to Associate Justice Eleanor Watkins, the court's most senior member, a position so competitive that fewer than 1 in 500 applicants receives it, a position that requires the most rigorous federal background check available to a civilian employee, a position that Marcus earned by being, in the judgment of one of the 9 most powerful jurists in the country, the best available legal mind for the job. Officer Dale Dillard has been with the District Police Department for 9 years. He has 11 prior complaints on his record. 7 of them involve black men. All 11 were dismissed. This arrest will last 4 hours. It will trigger a federal civil rights investigation, a Department of Justice prosecution, and a trial that ends with Officer Dale Dillard sentenced to 15 years in federal prison. It will also trigger a broader investigation into the district's policing practices outside federal buildings that results in the forced restructuring of an entire precinct. Type Supreme Court if you want to know how many of those 11 complaints were taken seriously before this morning. This story proves that in America, even the steps of the highest court in the land are not neutral ground for a black man with a badge that a white officer has decided, before reading a single word on it, cannot possibly be real. Marcus Reid grew up in Baltimore, Maryland, the only child of a high school history teacher and a civil engineer. He was the kind of student who finished his assignments and then went looking for harder ones. The kind of kid who argued with his teachers not out of defiance, but out of genuine intellectual hunger, who worked his way through his father's entire shelf of legal history books by junior year of high school and then asked for more. He was not performing ambition. He was following curiosity wherever it led, and it kept leading to the same place, the law, and the distance between what the law promised and what it actually delivered to people who looked like him. He graduated valedictorian of his high school class. Full academic scholarship to Howard University, where he majored in political science and graduated with honors. He went directly to Howard University School of Law, and 3 years later graduated summa cum laude, first in his class, Order of the Coif, and editor-in-chief of the Law Review. His third-year paper on equal protection jurisprudence was cited in 2 federal circuit court opinions before he sat for the bar exam. After law school, he clerked for a federal circuit court judge for 1 year, the standard professional stepping stone for clerks aiming at the Supreme Court. Then he applied. Out of approximately 500 applicants for Justice Watkins's 2 annual clerk positions, Marcus was selected. The selection process involved a 4-month federal background investigation that reviewed every aspect of his personal, academic, and professional history before clearing him for access to some of the most sensitive legal deliberations in the country. He had been working in the Supreme Court building for 7 months on the morning of October 7th. He knew the security staff by name. He swiped through the main entrance with his government credential every morning at 8:15 a.m., walked to his third-floor office, and spent his days drafting bench memoranda, researching precedents, and helping prepare Justice Watkins for oral arguments in cases that would shape American law for generations. He was not a visitor to that building. He was one of 38 people in the entire country selected to do the work that happens inside it. He arrived on October 7th carrying a leather briefcase, a travel coffee cup, and a folder of bench memoranda he had finished drafting at 11 p.m. the previous night. A case was being argued in 3 days. The preparation was not complete. He walked up the steps with his mind already in the building, already on the argument structure he had been refining for 2 weeks. He was 4 steps from the entrance when Officer Dale Dillard stepped into his path. Dale Dillard had been with the District Police Department for 9 years on the morning of October 7th. He was assigned to the Supreme Court Exterior Detail, a federal support posting placing district officers in an exterior role, while the Marshal Service managed interior security. The assignment carried specific written protocols about pedestrian stops near federal property. Those protocols required, as a condition of any stop, that the officer be able to articulate a specific reason for initiating contact beyond general appearance or location. Dillard had 11 complaints on his departmental record. 7 involved black men. The complaints described stops that could not be justified by articulable suspicion, use of language described as racially demeaning, and in 3 separate instances, the dismissal of identification presented by black individuals as insufficient or possibly fraudulent. All 11 complaints had been reviewed by Internal Affairs. All 11 had been closed without formal disciplinary action. The reviewers who closed them are named in the subsequent DOJ investigation. In the 6 weeks before October 7th, the exterior stop log for the Supreme Court detail showed 14 pedestrian stops. 12 involved black or Latino individuals. 0 resulted in any confirmed security threat or criminal activity. None was reviewed by a supervising officer. Marcus was the 15th stop. Dillard stepped into his path and demanded identification before Marcus had spoken a word. Marcus reached for his badge without hesitation, held it out in plain view, and watched Dillard take it. The badge was issued by the United States Marshal Service. It carried the embossed seal of the Supreme Court on its face. Marcus's name and photograph, his employee number, his security clearance level, and on its reverse side, the Marshal Service authentication number and the direct verification line for the Office of the Supreme Court Marshal. It was one of the most visually distinctive federal credentials in existence, designed to be immediately recognizable to anyone working in or near federal law enforcement. Dillard looked at it and laughed. He held it up for Walsh and called it a party store purchase. Walsh smirked and asked whether the government seal was supposed to look like that. Marcus told them to call the security desk 15 feet behind them, or call Justice Watkins' chambers, or call the Marshal Service authentication number on the reverse of the badge Dillard was holding. 3 verification options. Any one would confirm his identity and employment in under 2 minutes. Dillard put the badge in his pocket, told Marcus they would verify it at the station. What Dillard saw when Marcus extended that badge was not a credential, it was a claim. And the claim? That this black man in his 20s standing on the steps of the Supreme Court worked there, belonged there, held one of the most competitive legal appointments in the country, did not fit the story Dillard had already constructed before Marcus reached the top of those steps. So the badge became a fake, not because anything about it suggested fraud, because the person presenting it made legitimacy seem, to Dillard, implausible. The same badge in the hand of a white man in the same suit carrying the same briefcase would have produced a different response. Not because the badge would have looked different, because the assumption about who could legitimately be holding it would have. The handcuffs go on at 8:13 a.m. on the steps of the United States Supreme Court. 2 minutes after Marcus arrived for work. In view of the building's exterior security cameras, the Marshal Service checkpoint, visible through the glass entrance doors 15 feet away, and approximately 30 morning pedestrians on the surrounding plaza, several of whom stop walking when they see it. Marcus does not resist. He has spent enough time studying the law to understand precisely what resistance in this moment would cost him, and the cost would be paid entirely by him. And the situation is already going to be more than sufficient to produce every consequence it needs to produce, without adding to it. He states that he is complying voluntarily. He asks Dillard to note the time. He observes, evenly, that the building behind them has exterior cameras covering this section of steps from multiple angles. His briefing folder lands on the steps when Dillard takes his arm. Documents prepared for a case being argued before the United States Supreme Court in 72 hours. Pages lying on the stone where they fell, while their author has walked to a patrol vehicle with his hands behind his back. Inside the building, at 8:17 a.m., Justice Watkins' senior clerk notices that Marcus has not arrived and has not sent a message. He is never late and has never failed to communicate a delay. Front steps. She sees the patrol vehicle. Front steps. She sees the patrol vehicle at the curb. Through the rear window, she can see Marcus's Supreme Court lanyard visible on the back seat. She goes directly to Justice Watkins's office. Justice Eleanor Watkins has served on the Supreme Court for 19 years. She is known for three things: a legal intellect that colleagues describe as the most rigorous on the bench, a personal composure that does not vary under any circumstances, and a total and documented intolerance for institutional disrespect directed at the people who work for her. She picks up her direct line to the Marshal Service. Then she calls the United States Attorney's Office. Marcus is processed, photographed, and placed in an interview room at the district precinct. His briefcase, his phone, and his lanyard are logged as personal effects. The folder of bench memoranda is bagged and tagged in the evidence system as potential fraudulent materials. He asks to make a phone call. He is told access comes after processing. Processing takes 40 minutes. At 8:34 a.m., the Marshal Service Supervisor calls the precinct watch commander. He provides Marcus's name, badge number, and employee identification. He states that a sitting Associate Justice of the United States Supreme Court is personally requesting verification and immediate release of her law clerk. He speaks with the clarity of someone who has made calls like this before and knows exactly what the person on the other end is about to understand. The watch commander pulls up the booking record, looks at the evidence bag on the counter, looks at the Supreme Court seal visible through the clear plastic, sits down. At 8:52 a.m., the Marshal Service Supervisor arrives at the precinct in person with Marcus's federal employment record, his full security clearance documentation, and the letter on Supreme Court letterhead signed by Associate Justice Eleanor Watkins, requesting the immediate return of her law clerk and all personal effects, including the official court documents currently logged as fraudulent materials. Dillard is called into the watch commander's office at 9:04 a.m. He is shown the employment record, the clearance documentation, the letter, the badge, removed from the evidence bag and sitting on the desk where every authentication marker is visible to anyone who holds it for 30 seconds and looks at it. Dillard says he had no way of knowing the badge was real. The watch commander looks at the badge, then at Dillard, then picks up the phone. Marcus is released at 12:19 p.m., 4 hours and 6 minutes after he was handcuffed on the steps of his workplace. The folder of bench memoranda is returned in its evidence bag, which a desk officer has to cut open with scissors. Marcus retrieves each page, checks the order, straightens the stack, and places it back in his briefcase. He is offered an apology. The word the desk sergeant uses is miscommunication. Marcus does not respond to the word miscommunication. He collects his belongings, picks up the lanyard that has been folded and creased through the Supreme Court seal, and walks out. Justice Watkins's car is at the curb. Her senior clerk is in the back seat. Marcus gets in. He is at his desk by 12:37 p.m. He opens the folder and works until 9 p.m. The case is being argued in 60 hours. The work does not pause for the morning. Justice Watkins comes to his office at 6 p.m. and asks him to tell her everything from the beginning. When he finishes, she tells him the matter will not be minimized or managed quietly, that the DOJ Civil Rights Division opened an investigation at 11 a.m., and that the bench memoranda are excellent. Then she returns to her own office and continues working. Both of them do. This case does not become a civil lawsuit. It becomes a federal criminal prosecution. And the distinction is the story. Because what Dillard did on the steps of the Supreme Court was not only a civil rights violation addressable through damages and settlement, it was a federal crime. Detaining a federal employee in the performance of official duties, filing a false federal report characterizing official government credentials as fraudulent, and doing both while assigned to a federal facility on the basis of race. These do not go to a settlement negotiation. They go to a grand jury. The DOJ Civil Rights Division and the FBI Civil Rights Unit open a joint investigation 8 hours after Marcus's release. Subpoenas for both officers' body camera footage, the Supreme Court exterior security recordings, and the district's complete exterior stop records for the 6-week assignment period are served within 48 hours. Walsh contacts the DOJ through his attorney in week 3. His cooperation agreement requires full testimony in exchange for a reduced charge. He confirms that Dillard saw the Supreme Court seal before laughing. He confirms the laughter was not confusion. He confirms that Dillard said, before the stop, that the guy is trying to walk into the Supreme Court, and he is going to find out why. Marcus had not yet reached the steps when Dillard said it. The grand jury returns an indictment in month 4. 5 counts. Deprivation of civil rights under color of law. Filing a false federal report. Obstruction of justice. Interference with a federal employee in the performance of official duties, and a federal hate crime enhancement on the basis of the stop records and Walsh's pretrial testimony, establishing that the stop was initiated on the basis of race before Marcus said or did anything. Dillard is arrested at his home on a Tuesday morning. Walsh surrenders voluntarily the same afternoon. In the weeks between the incident and the indictment, Marcus Reid continues going to work. Every morning he walks up the same steps, swipes through the same entrance, sits at the same desk, and prepares the same kind of bench memoranda for the same cases being argued before the same court. He does not take a leave of absence. He does not request a schedule adjustment or an alternate entrance route or any modification to the routine that Dillard disrupted for 4 hours on a Tuesday morning. He walks up those steps because they are his to walk up, and because the most precise and pointed response available to him is to keep doing the job that made the incident happen. He also files a civil suit, parallel to the criminal prosecution, with attorney Denise Carver, one of the leading civil rights litigators in Washington. The civil case names the district, Dillard, Walsh, and the supervisory officers who reviewed and dismissed all 11 of Dillard's prior complaints without formal disciplinary action. He is asked in a pretrial deposition whether he considered the possibility that the stop was not racially motivated. He says he considered it for approximately the duration of the laugh. Then he stopped considering it. The prosecution's evidentiary record is assembled with the same precision Marcus applies to bench memoranda. The body camera footage becomes Exhibit A, professionally analyzed and frame annotated. The annotations identify the Supreme Court seal visible in frame at 0 seconds. The badge received at 8:13 a.m. The badge held unexamined until 8:28 a.m., when a supervisor at the precinct first opened it. 15 minutes, during which the authentication information needed to resolve every question sat in Dillard's pocket, while Marcus sat in a patrol vehicle. The dispatch timeline becomes Exhibit B. Badge presented 8:13 a.m. Badge examined 8:28 a.m. Marcus released 12:19 p.m. Bench memoranda tagged as fraudulent materials at 8:41 a.m. Bench memoranda returned at 12:22 p.m. The stop log becomes Exhibit C. 14 prior stops, 12 involving Black or Latino individuals, 0 resulting in confirmed security concerns, 0 reviewed by supervisors. Dillard's personnel file becomes Exhibit D. 11 complaints, 7 involving Black men, specific language from 3 complaints describing Dillard dismissing identification presented by Black individuals as insufficient or possibly fake. All 11 closed without formal discipline. Reviewing officers named. The federal credential authentication expert retained by the prosecution will testify that the Supreme Court employee badge contains 7 distinct authentication features standard across all Marshal Service-issued credentials. That any officer assigned to a federal building exterior would be expected to recognize them as part of their standard assignment briefing, and that a genuine examination of the badge would have revealed those features in between 15 and 30 seconds. The badge was in Dillard's possession for 15 minutes before it was opened. The trial runs for 11 days. The prosecution builds its case on 4 pillars: the footage, the records, Walsh's testimony, and Marcus Reid. Marcus testifies on day 3. He approaches the witness stand the way he approaches a bench memorandum, chronologically, specifically, and with every statement supported by something already in the record. He describes the 4 steps. He describes extending the badge. He describes the laugh. He describes offering the security desk, Justice Watkins's chambers, and the Marshal Service authentication line, and watching each offer refused. He describes the handcuffs going on 15 feet from the Marshal Service checkpoint. He describes the evidence bag. He describes arriving at his desk at 12:37 p.m. and working until 9 p.m. because the case was being argued in 60 hours. He does not editorialize. He does not reach for emotion. He states what happened in the sequence it happened and lets the jury sit with it. One juror cries. The judge notes it and says nothing. The federal credential authentication expert testifies on day 6. He explains the 7 authentication features. He is asked how long a genuine examination of the badge would have required. He says 15 to 30 seconds. He is asked how long the badge was in Dillard's possession before it was examined. He says 15 minutes. He does not elaborate. The jury does the arithmetic themselves. Chief Michael Reeves, retired FBI special agent with 28 years in the Civil Rights Unit, testifies on day 8. He calls the tasing, the stop, the detention, the false report, unjustified under any reasonable standard of federal law enforcement conduct. He calls the false report the most significant element of the case because it demonstrates that the violation was not a moment of poor judgment, but a calculated attempt to construct a record that would protect that judgment from review. He says in 30 years of reviewing civil rights cases, he has rarely seen documentation of intent this explicit. Walsh testifies on day 9. He confirms every material fact: the statement before the stop, the laugh, each refusal, the decision not to contact the checkpoint, the conversation in the patrol vehicle in which Dillard said the badge was probably printed at a copy shop. Dillard does not testify. His defense argues good faith error by an officer who could not have been expected to authenticate a credential he had not been trained to recognize. The prosecution spends 45 minutes of closing argument on a single question. If he could not recognize the credential, why did he laugh at it? Good faith errors produce confusion. They produce verification attempts. They produce the phone call to the checkpoint 15 feet away. They do not produce laughter. Laughter is recognition. Laughter means Dillard saw exactly what the badge said and decided in the moment of seeing it that it could not be true. The jury deliberates for 3 hours and 40 minutes, guilty on all 5 counts. At sentencing, the judge speaks for 22 minutes. She notes that the crime occurred on the steps of an institution whose founding purpose is the protection of the rights violated on those steps. She describes the false report as an aggravating factor of the highest order, because it was not a mistake, it was a choice. A choice to construct a false record around a real person whose only action was presenting irrefutable credentials to an officer who had already decided, before they were presented, that they could not be irrefutable. She sentences Dale Dillard to 15 years in federal prison with no parole eligibility for the first 10. Walsh receives 4 years under his cooperation agreement. The criminal sentence is the headline. The architecture built in its aftermath determines whether it means anything beyond one man's term. The DOJ's parallel investigation into the district's exterior federal building assignment practices produces a finding of systemic racial targeting across 4 precincts. 47 officers are placed under formal review. 11 are terminated. The exterior assignment program is suspended, pending a full structural overhaul with mandatory federal oversight and new stop documentation protocols requiring supervisor sign-off on any pedestrian contact within 500 feet of a federal facility. The district is placed under a 5-year consent decree requiring independent monitoring of all pedestrian stop practices, mandatory bias training for every officer in the department, quarterly reporting to the DOJ Civil Rights Division, and the creation of a civilian oversight board with subpoena authority over internal complaint records. All 11 of Dillard's prior complaints are reopened and reviewed by an independent examiner. All 11 are found to have been dismissed without adequate investigation. The supervisory officers responsible for those dismissals are formally reprimanded. 3 are required to appear before the Civilian Oversight Board to account for their decisions. Marcus Reid's civil suit settles for $4.8 million. The settlement contains, at Marcus's insistence and as a non-negotiable condition of any agreement, a written acknowledgement. Not standard legal language, not a boilerplate disclaimer, a specific, drafted, named statement acknowledging that on the morning of October 7th, Marcus Darnell Reid was stopped, detained, and arrested on the basis of his race while performing his lawful duties as a law clerk of the United States Supreme Court, in violation of the rights guaranteed by the Constitution he was employed, at the moment of that violation, to help interpret. The United States Supreme Court Marshal Service issues revised exterior security protocols for all federal court facilities nationwide. Any law enforcement officer who questions the validity of a federal employee credential must initiate contact with the issuing agency before taking any action against the credential holder. The internal implementation memo transmitting these protocols to every federal court security operation in the country refers to the new standard without elaboration as the Reid Protocol. 15 years in federal prison, 4 years for Walsh, 47 officers under review, 11 terminations, a consent decree, a civil settlement with a named written acknowledgement, a federal protocol distributed to every court in the country carrying his name. And none of it reaches the 3 seconds on those steps. The 3 seconds in which Dale Dillard saw Marcus Reid coming up toward the entrance and decided, before a word passed between them, before a badge was extended, before a single piece of information changed hands, that this person required explanation. The 3 seconds in which the prior construction of who stands on those steps and why, of what level of credential a person who looks like Marcus can reasonably be expected to carry, of what the building behind him can and cannot plausibly contain, was already complete and already generating its outcome before the laugh came out of Dillard's mouth. The Supreme Court seal did not interrupt those 3 seconds. The Marshal Service authentication markers did not interrupt them. The 3 verification offers did not interrupt them, because they were not about the badge. They were about who was holding it. The 15 years addresses what Dillard did after those 3 seconds. It does not address the 3 seconds themselves. The consent decree creates procedural interruptions that may, in some encounters, slow or prevent the action that follows the assumption. It does not reach the assumption. The Reid Protocol requires a phone call before detention. It does not require and cannot require that an officer look at a black man on the steps of the Supreme Court and not feel, instinctively and without examination, that he requires explaining. That instinct is not a training gap. It is not correctable by a revised briefing curriculum or a mandatory demographic audit or a 230-page Inspector General's report. It is the accumulated residue of a story this country has been telling about who belongs where, at what level of authority, in what institutions, that has been told for long enough to stop presenting itself as a story. It presents itself as common sense. It presents itself as the obvious reading of a situation. It presents itself, in the 3 seconds on those steps, as recognition. Marcus Reid walks up those steps every morning. He has not stopped. He does not intend to stop. The steps belong to him in the precise legal sense that the credential in his pocket grants him access to what is behind them, and in the broader sense that he earned the right to walk up them by being, in the judgment of a sitting Supreme Court justice, the best available legal mind for the work that happens at the top of them. He understands the law, and the gap between what it promises and what it delivers, more completely now than he did before October 7th. He understood it well enough before, but there is a difference between understanding it as a scholar and understanding it as a man who had his federal badge laughed at on the steps of the institution that issued it. He carries both kinds of understanding now. He uses both of them, every day, in the building at the top of those steps. Marcus Reid graduated first in his class from Howard University School of Law. He was selected from 500 applicants for one of the most competitive legal appointments in the United States. He holds a federal security clearance that took 4 months to issue. He works in the building whose steps he was standing on when the handcuffs went on. His badge carried the seal of that building, the authentication of the United States Marshals Service, and the direct line to a sitting justice's chambers. He offered 3 verification options. The checkpoint was 15 feet away. He was laughed at, handcuffed, held for 4 hours and 6 minutes. His bench memoranda were tagged as fraudulent materials in a district evidence system. Dale Dillard is serving 15 years. The building Marcus works in is still standing. Marcus is still in it. So here is my question. If a Supreme Court employee credential bearing a federal seal, a Marshal Service authentication number, a security clearance designation, and a direct line to a sitting justice is not enough to prevent a black man from being handcuffed on the steps of the institution that credential was issued to serve, what would have been enough? Should officers assigned to federal facilities face automatic federal charges, not just internal review, every time a pedestrian stop cannot be justified by specific articulable facts beyond the race of the person stopped? And should the supervisors who reviewed and dismissed all 11 of Dillard's prior complaints face criminal liability for the harm that their 11 dismissals made not just possible, but statistically inevitable? Share your thoughts in the comments. This story proves that achievement does not protect you from suspicion. Credentials do not protect you from suspicion. The steps of the highest court in the land do not protect you from suspicion. But it also proves that federal prosecution is a different instrument than a dismissed complaint, that 15 years is a different consequence than an internal review that goes nowhere, and that when the institution whose steps this happened on decides the matter will not be minimized or managed quietly. The outcome for the man who laughed at that badge is something he will spend the next 15 years in a federal prison thinking about. Thank you for watching. I will see you in the next story.